In today's video, I'm going to be taking you into my computer to show you step by step how to complete the exclusive right to represent a purchaser in the state of Virginia. If this is your first time on the channel, my name's Amanda. I teach other real estate agents how to build their business without ever making a cold call. If that's something that interests you, be sure to hit that subscribe button and tap that bell for notifications so that you'll never miss a video. All right, so here we are. I am in ZipForms. That's what I use to write up, purchase agreements, listing agreements, and in this case, a buyer agreement. And I'm just going to walk through each page of the exclusive right to represent a buyer. And let me scroll down a little bit. Here you have your date field, pretty straightforward. eXp Realty is, of course, my broker. So that's already completed because I have my ZipForms set up in templates to try to save myself some time of continually writing and filling out the same things. Definitely recommend that no matter what transaction management system you're using, set up those templates. Buyer, of course, pretty straightforward. In this case, I'm just going to say that I'm the buyer. And then I'm going to come down a little bit further. The appointment of broker essentially says that this agreement is granting the broker the right to represent the buyer for acquisition of real property. And a little bit further down, we'll get into a more precise description of what that real property is as it pertains to your specific buyer. Buyer representations is they are representing and signing off on that they are not committed under any other buyer broker agreement. And that really should be a question that you ask immediately before you even get to completing this buyer representation agreement. Ask if you have a lead. I don't use working with, I use the word, are you committed to an agent? Because working with, I've found over the years for buyers can be misinterpreted and they don't understand that I'm asking if they are essentially under contract with another agent, not on a property, but under contract on this buyer representation agreement. These can be canceled pretty easily, but I do think that they're important. And in Virginia, it's the law that you have one in place. So you definitely want to get to this very early on. And then we're going to come down here to continue filling this out. For the buyer information, I typically complete their cell phone and their email. Nothing wrong with completing their address, but if I already know their cell and their email, it's readily available, that's what I will fill out. Broker, this is the broker that you're working for. So this is your office address, office phone number, and then the email that ties to your broker, not your information. Then we're going to come down here a little bit further, and I'm going to start filling this out now that we're past just the basic admin stuff. This is the term and the termination of this agreement. So whatever the date is that you put at the top of the agreement, that's when this is going to be starting. And this is when it's actually going to expire. So that's up to you and your buyer. I would recommend somewhere in the 6-month time frame, depending on what your market is doing. It's better to have one set up for longer than shorter. So you'll have to make that judgment call, but I would say somewhere in the 6-month range. I'm just going to click a date for now. Early termination fee. Again, that's up to you on whether or not you want to charge one. I do recommend if you're putting a termination fee in one buyer broker agreement, then you should do it across the board and vice versa. If you put 0 in, then do that across the board. Do not change in between clients, because should there ever be any trouble, that could be viewed as discrimination, and that's not a position you ever want to be in. So it's up to you. My standard termination fee for buyers is $750. So I'm going to put that in there. And that doesn't mean that it has to be charged. Oops, that just jumped. It's really up to you and your broker. If this agreement is severed and the buyer had a valid reason to terminate it, it doesn't mean that you have to pursue the compensation. But if it's in there, then you certainly have the right to. That's a topic for another video though, because that can go down a rabbit hole of different scenarios of why these are canceled and if it's, valid, etc. Broker's duties. This paragraph outlines what you as the buyer's broker are responsible for. And essentially what this says, I'm not going to read through every single thing. Essentially what this says is you are responsible for representing their best interests at all times, and you are always responsible for providing and disclosing all material facts that you know. Different scenario if something isn't disclosed to you, but anything that is disclosed to you that is a material fact related to the property or concerning the transaction in general, you need to disclose that. This paragraph also, it kind of cuts off here, but this paragraph, I also like to point out to buyers that it points out that as a buyer's agent, you are permitted to show the same property to different buyers, and you are permitted to represent other buyers on the same or different properties. And that comes into play somewhat frequently when inventory is so low. We're still experiencing that here in Northern Virginia. So I think it's important because this is based around a Virginia buyer's agreement that you are still free to show a property. If you have multiple clients looking for the same thing, that's okay. You're still permitted to show all of your buyers that property. The buyer's duty. By signing this agreement, they are acknowledging that they are working exclusively with you during the term of the agreement. And it's also stating that they will pay the broker directly or indirectly the compensation that's outlined below, which we'll get into a little bit later. And then it's stating that they will comply with supplying you with pertinent financial information or personal information need to fulfill the terms of the agreement. And it's also stating that they will be available during the broker's regular working hours to view properties. This is very important because those buyers, simply because they don't know the process, they don't know that they're agreeing to certain duties as well. So I recommend going over these with your clients before they sign. In this world of e-sign, which don't get me wrong, I don't miss the days of having to go meet clients to physically get paperwork signed off on. I think that it's created a little bit of a gap though, because these documents are sent via e-sign, whatever program you use. And sometimes buyers and sellers, they just don't read them. So make sure you're doing your part to explain everything. This also, this last part of this buyer's duty paragraph is the buyer's acknowledging that the seller may have a video and or audio recording system in the property, even if prior disclosure is not made. So when you're working with buyers, always check your MLS to see if a disclosure is made. But how I operate when buyers and I first meet to tour our first home, before we ever walk up, I tell them, listen, just assume that you are on video and you're being recorded. Don't say anything that could impact negotiation power. It's just safer and, quite frankly, easier to have a blanket statement. Whether you're being recorded or not, it doesn't really matter house by house. Just protect your clients and let them know, hey, don't say anything that could damage our negotiation position in the event that they do like the house. Here's where we're going to get into why this buyer is retaining you and the type of property. And depending on what type of property it is, in this case, I'm going to say residential, and I'm going to give a little description about what I, as the example buyer, am looking for. I'm going to say single family home in Fairfax County. It doesn't have to be super detailed, but I would list something more than just residential, give a little bit of insight into what this buyer is looking for. And really that is to protect you in case something doesn't go as planned. And this buyer broker agreement comes into play, whether it's in arbitration or some other more formal format of depending which direction things are going to go. Make sure that you give a little bit of detail here. Compensation. Whether or not you charge a retainer fee is entirely up to you. I'm going to put $500 in here and state that it will not be subtracted from any compensation. So this retainer fee is in addition to the commission. And then payment is going to be whatever you have agreed upon with your buyer client. So I'm going to say 3% of the final sale price. Again, that's up to you and your client. I'm not going to get into commission very much. This is just where you complete what that buyer owes you compensation wise. And then it goes on to say that if the buyer enters into a contract to acquire real property during the term of the agreement and goes to settlement on that contract anytime thereafter, in most cases, the seller pays the broker's fee, but in the event the seller does not pay any or all of the amount due, the buyer is agreeing to pay any and all remaining broker's fee due to the buyer's broker. So let's say you have 3% in your buyer's agreement, and then they go under contract and settle on a house that is 2.5%. Legally, you can seek that additional 0.5% if that's what you chose to do. But if you are comfortable accepting the 2.5% that was offered by the listing, by the sellers, then that's fine as well. It really depends on how you want to handle that. This simply protects you when once everyone signs off on it, that if you do want to seek the full compensation that is listed in your buyer broker agreement, you certainly can. This next one is very, very important. This is stating that if within X amount of days, I always put 60 here, after the expiration of this agreement or after the early termination of the agreement, if the buyer enters into a contract with another real estate agent, then that buyer still owes the compensation under this buyer broker agreement. And this can get really dicey really quickly. So again, I'm not going to go on the rabbit hole because I really want to focus on showing you how to fill out this buyer agreement. But make sure that you fill out that number of days. Again, it's up to you how much you list. I have always done 60 days for, I'm going to say, as long as I've been in real estate, which is over 15 years now. I really don't remember a time where I haven't done 60 days. Now let's come down here. Relocation program. This is if the buyer is participating in a program, maybe through their employer, then you would want to list that information here and what the terms of the program are. I'm going to say no because I don't have an example of anything to work from. I could probably make one up, but if they're working, with Cardis or someone like that, some official relocation program, then you'll want to get the terms of that program and just put them in the buyer broker agreement, particularly if it's a relocation company. Most of the time they have their, affiliated agents, but if for some reason they don't and you have signed on to help this buyer, make sure you find out if there's any type of commission rebate or referral fee that has to be paid either to the buyer on the settlement statement or to the actual relocation company. This goes into the types of real estate representation. If you are not in Virginia, this may or may not apply to your state because Virginia does allow dual representation. And this is where you're acknowledging whether or not the buyer consents, but it also is acknowledging whether the buyer consents to designated representation. So two-part conversation that you want to have with your buyer prior to completing this so they know what the two things mean and whether or not they want to consent or if they do not consent. Designated is if, let's say that you are showing a listing, you and the listing agent both work for eXp Realty, then you would technically be operating under designated representation because you both agents work for the same brokerage. Dual representation is a completely different story, and that is when you are representing both the buyer and the seller. I personally do not practice dual representation, so all of mine are always no here. I compare it to going to court and the plaintiff and the defendant both having the same lawyer. I just don't think that it's ethically correct. And I think it is a disservice to buyers and sellers. I will stop there because I can quickly get on my soapbox about dual representation, and that's not what we're focused on today. Compliance with fair housing. You should all know your fair housing laws, both federal and state. So I'm not going to dive into that. It's essentially saying that property will be shown regardless of race, color, religion, sex, handicap, et cetera, et cetera. Attorney fees, always an important one, hopefully never becomes an issue, but it is included in the buyer broker agreement. It's stating that if any party breaches agreement and a non-breaching party retains legal counsel to enforce its rights, the non-breaching party will be entitled to recover against the breaching party. In addition, any other damages recoverable against any breaching party. So essentially what this is saying in a nutshell is if the agreement is breached and the party who has to then hire counsel to work through it, they can seek the attorney fees back from the party that breached the agreement. Scroll down here a little bit more. Always have to find out whether your client does or does not hold an active or inactive real estate license. I'm going to say yes, because I do have a license, and this is important as well. In the Virginia state contract, there is an additional section that if your client, or if you're representing yourself, has an active or an inactive real estate license, that must be disclosed. And there's a section in the sales contract for that. Disclaimers, I'm just going to touch on these briefly. Again, I don't want to make this video too long. It's more to show you how to properly complete this, study this agreement, and know it on your own. Professional services, this is acknowledging that you are, as the agent, being retained solely for real estate advice, not tax advice, not, lender, appraiser, etc. You can make recommendations and counsel, but in terms of legal advice, you cannot give any, and the buyer has to seek their own legal advice. Megan's Law, we don't need to go into that. Everybody knows about Megan's Law. You can always send the link here if your buyers want to look up proximity, sex offenders' proximity to a house they're interested in. You can send them that link. Wire fraud, whether it's a buyer broker agreement, contract, listing agreement, I don't care. Make sure your buyers and your sellers are well aware of wire fraud. EXP has an additional form to supplement this that it's an advisory, and it's to keep everybody aware that wire fraud is rampant in real estate. Just protect your clients the absolute best you can and make sure that it's on their radar so that they know if they get an email saying, here are your wire instructions, that they need to call the title company to verify and do not respond to that email just in case it's somebody phishing. Service provider referrals, this is stating that, we as agents can make recommendations. It doesn't mean that it's an endorsement or anything like that. And it encourages the buyer to also do their own research and go with whomever they feel is comfortable, whoever they feel comfortable with. Miscellaneous, this essentially says that oral agreements are not going to supersede this agreement. And in order for things to be enforced, they need to be in writing and signed by both parties. If you want to add some other provisions here, you can. You could use this section if you've made any, I don't want to say exceptions, but if you've made any agreements outside of what's highlighted in this buyer agreement, then you could note those here. In some cases, maybe you are paying a referral fee to another real estate agent. I always disclose that here because I want my buyers to know that there is a referral agreement in place. We want everything transparent. This is really just for custom circumstances and fill it out as needed, or oftentimes it's blank. This big note in Virginia's buyer agreement that I love that they've added is in regard to new home sales. Buyers should consult with buyer agent before visiting any resale or new homes or contacting any other real estate agents representing sellers to avoid the possibility of confusion over the brokerage relationship and misunderstandings about liability for compensation. This is huge. Point this out to your buyers, especially if they are considering new construction. You have got to be present with your buyer when visiting new construction communities for the first time, unless you've contacted that community and made some other arrangements with the sales rep. But make sure your buyers know that if they're, out driving around on a Saturday and they stop in to the newest new construction community and start having a conversation with the sales rep, make sure that you tell them if they are planning on doing that you need to, at a minimum, call that sales rep first and let them know your clients are going to stop by, or best protocol, be with your clients. Or if you have a showing agent, have them with your clients. Someone who is a licensed agent and representing them needs to show up. That's the best case scenario. And then down here, you can fill out, depending on whether or not your broker lets you sign your own agreements. Here, I list my broker's name, and then I also list my name. And I sign these myself, so that's why I list both. Can't type my own name today, apparently. There we go. And then down here, this is already completed. Again, because of the template, I fill out my team name. And then you, again, want to come down here and fill out your broker's name, phone number, and email. So that is how you fill out an exclusive right to represent a purchaser. Again, this needs to be completed after your first substantial conversation or communication about real estate. Do not, show them 10 homes and then decide to get this agreement completed. This is important. It's a legal requirement, and it protects both you and it also protects your client. You want to have that loyal working relationship, and they need to understand that this is an official agreement, and it's important that they are willing to sign off, because if they're not, that's a red flag. If you've had a good conversation or had a good meeting and then they aren't willing to move forward with signing off on you exclusively representing them, one, I would do some more digging into why, but two, I would also view it as a red flag as to why they don't want to make your working relationship official. I hope you got some value from today's video. If you have any questions, drop me a comment below. And as always, until I see you on the next one, take care.